So the real value of controlling the ownership and use of your deliverables is to protect your compensation. And that's why we'll be talking about intellectual property, mostly copyrights, in this program. We'll look at the business risks that you face when you provide information to your client, and look at the federal copyright law and other intellectual property protections. We will briefly discuss the copyright laws and tell you where to get more information. We certainly can't cover all aspects of federal copyright law in this short webinar. We will discuss what project clients really need and what they think they need to enable them to complete a project and for any future additions or modifications or renovations to a project you design. And this program will include a mention, but that's about all, of other forms of protection for intellectual property. And we, of course, will be emphasizing protecting your bottom line. Now, what is intellectual property? Here's a standard definition. Focus on the beginning of that definition. Intellectual property is a commercially valuable product. And that's why it's important. Because, again, it is something you create, and you should be able to make money from that creation. Some of you may carry around with you a copy of the U.S. Constitution. If you have it, turn to Article 1, Section 8, Clause 8. That part of the Constitution empowers the United States Congress to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. In the Constitution, I think our fathers understood that there was commercial value. In order to increase productivity, in order to increase inventiveness, you give people the right to protect their work. This is a source of congressional power to enact legislation governing copyrights and patents. It's often referred to as the Patent and Copyright Clause of the Constitution. So the government has a right to provide protection for creators, but why does that matter? Well, these are the reasons you should be concerned about protecting your work. Obviously, protecting public health and safety is a basic part of what you do as a licensed design professional. Preventing unauthorized changes to the design help you keep that integrity of your creation, the moral right mentioned above. Protecting your documents means that you can mitigate, you can reduce the risk that there might be some future claim from misuse or reuse of your documents. That's an unusual situation. It's one that I think a lot of people are afraid of. It doesn't happen very often, but that should be a concern. And finally, preserving the commercial value of your documents means that you can leverage the payment for your creation. It really provides you the leverage to collect your fee. And let's talk a little bit about statutory copyrights. We will not spend much time on the forms of intellectual property. We really want to focus on the copyright part. Prior to 1909, there was a set of common law principles governing copyright. And like with patents, there was no federal system put in place at that time. That changed with the first copyright law in 1909. And what I think interesting is one of the first users of the copyright law was Samuel Clemens, who shortly before his death in 1910 sought to obtain protection for Mark Twain, his pseudonym, his image, and of course, all of his published works. He anticipated that the benefits of protection would come, and the Mark Twain Foundation now reaps some of those benefits. He was able to, I think, obtain protection for some pictures and, of course, for his publications. The copyright law was changed significantly in 1976. This is known as the Disney version, where the Walt Disney company owners basically lobbied Congress to protect Mickey Mouse for many years. They did not want that to become part of the public domain. So, and it was changed again in 1990, mostly because international law, through something called the Berne Convention, was ahead of U.S. law on architectural works. The copyright law in the U.S. was then changed to incorporate the Architectural Works Copyright Act, which protects the overall design of a building. And one of the first architects to benefit from the act was I.M. Pei. His firm, Pei-Koch Fried, designed the Rock and Roll Hall of Fame, which opened in 1995. Its image was of the building was reproduced on T-shirts and mugs and everything else to sell in the gift shop. The firm, Pei-Koch Fried, enforced its design copyright, was able to obtain royalties on what was produced using that image, and I think eventually sold the rights to the Rock and Roll Hall of Fame for a good amount of money. So it was another source of income. Now, trademarks and service marks, they're protected separately. You cannot, for example, copyright a name, such as Mark Twain, but you can obtain separate protection for a unique name. Note that usually a registered trademark is so noted by the R in the circle symbol, and some trademarks that are not registered but enforced by common law often have a TM or an SM warning attached to the name. Patents are a different form of intellectual property. They're very complex. They require the advice of a special patent attorney, not just any attorney. They have to be qualified as a patent attorney. And obtaining a patent is difficult, unlike registering a copyright. By the way, patent protection has been around since the founding of the U.S. Even Abraham Lincoln once obtained a patent for a walking boat. This was a boat that had special legs that would extend down and help it portage from one river to another. I'm not sure any was built, but there is a patent on file for that. Now, some design firms have attained patents. Engineering firms have done so for specialized component designs. Some architecture firms for prefabricated structures and some elements of projects. I think there's been attempts to have a design patent for some special tiny houses. But again, that is not easy to do compared to a copyright. And there are trade secrets. And some of you might protect your trade secrets. Your clients certainly try to do so. Clients often try to keep information they provide you out of the public domain. That is why they ask you to sign those business contracts known as non-disclosure agreements. You too might have company private information on how you operate that you consider a trade secret. And those are protected in a different way. They're not registered or filed. Now, we are looking at how the federal copyright law can protect your intellectual property and therefore your ability to protect your cash flow. And we will look at 4 elements of protection. First, I want to make sure you are aware of how standard AIA and EJCDC documents address the protection of intellectual property. Both the American Institute of Architects and that Engineers Joint Contract Documents Committee have language in their standard contracts that go a long way to protecting the right of the architect or the engineer to their instruments of service, their intellectual property. We're insurance counsel to both of those groups, and we often discuss with them issues such as protecting copyrights and properly using licensing agreements to transfer some rights to use the copyrighted documents. We also will look at the copyright law, and that special part of it, that is the Architectural Works Copyright Act. And then we will look at how many owners, often developers or government agencies, establish a contractual transfer of intellectual property rights of design firms, how they go about obtaining the rights that you otherwise would have. Okay, first the standard contract language. The standard documents carry forward the idea that plans, specifications, and other tangible items provided by design firms are not products, but are nothing more than that expression of the design for which the client is paying. It's the skill in the design and not the skill in drafting or writing that's being provided. By calling them instruments of your professional service, they are not considered products, subject to the Uniform Commercial Code and case law that establishes and enforces things like implied warranties that accompany products. Right? So when you're transferring information in any way, you want to avoid the idea that they are what you are selling to a client. You're selling your services. You're not selling a product. One other item that led the AIA to develop the idea of instruments of service was that under the common law copyright, and even in the 1909 law, commissioned work that you do for someone else, would be considered the intellectual property not of the creator, but of the person paying for the creation. Now, with the 1976 law, it is clear that the right to remain with the creator, unless the work falls into a narrow category of being a work made for hire, and we'll discuss what a work made for hire is a while. And again, of course, always be aware of the value of leverage, of using your documents for leverage. This is a B101 language in the edition released earlier this year. It did not really change from the 2007 edition language. If you look at that, if you read that, the first sentence preserves the right of the architect as the creator and of the architect subconsultants as creators. The second sentence is put in there to keep the information out of the public domain, and it really gives design firms a stronger chance to appropriately file for protection if they wanted to do that to protect their rights. So it's the idea that you are not putting this out there where someone else can have it. They should be aware that you still have the rights and retaining the rights to file for a copyright and protect them in the future. We will talk about licensing later on when we talk about owners wanting information. But here's the AIA language. It gives project owners what they actually need without giving away control of the documents. This has been expanded over the years to give owners more rights, but I think it's realistic. The idea that they have some right not to reuse the documents, but for the purpose of constructing the project, using the project, maintaining, altering, renovating, adding to the project. That's all part of the license. Now, this was changed slightly from the 2007 version, and part of it is to refer to Article 9. Article 9 is a new provision in the 2017 B101 that allows and actually tries to force the architect and the project client to predetermine a licensing fee that would apply if the contract is terminated for the owner's convenience or by the architect for cause. And we will talk about that provision later. Article 11 that this refers to the general compensation terms, including the one that says the client actually has to pay the architect before any license is effective. The Engineers Joint Contract Documents Committee also uses the instruments of service language, and it attempts to protect the engineer's right to basically reuse the same solutions on other projects, because much of what an engineer might do would be reusable, not just in minor details, but as a major part of the design, and they wanted to be able to protect that reuse. EJCDC, however, goes into much greater detail than the AIA about the owner's rights. Like the AIA, it establishes a license for the owner, but the details are much greater. It, of course, requires payment before the licensing takes place, and it emphasizes what we tell policy holders here in the information we publish on our website, that one, deliverables are suitable only for the specific project. Two, that the owner assumes any risk from any future use unless the original professional is involved. So both preserving your right to be involved in future projects and protecting you if the owner happens to take that information and uses it in any other way. This could be in modifications or renovations or even unauthorized reuse of the same information. The third part of it is the owner has to protect the design firm from meritless claims through a contractual indemnity obligation. This is the part that many owners object to. They don't want to have that indemnity hanging out for years in the future. And four, the license is not transferable or assignable or otherwise extended beyond the project owner. So the project owner can't simply say that some other party used these instruments of service. All right, let's discuss the copyright law. We will only do so briefly. There's more information in that copyright law paper, which was sent to you and can be downloaded, I think, from this presentation, and is being added to our website and available. And there's also a lot of information available from the U.S. Copyright Office. I'll point out some of those publications. Okay, let's talk about statutory copyrights and the 1976 Act. As I said, it removed the commissioning element from design plans and specifications. Unless the effort to create the intellectual property was within this narrow scope of a work made for hire, the rights remain with the creator, even if the original creation was commissioned by a client. Plans and specifications were not specifically enumerated as what is a work made for hire. The list, by the way, is a little vague, and you can look at it in the publications, but they did not include plans and specifications. I mentioned the Disney lobbying. It produced the extension of the length of the copyright in the 1976 modification. For instance, for a company-produced work such as this PowerPoint, remember I am an employee, so my employer owns this intellectual property. It is the 95-120 rule, which means it's a shorter of 95 years from publication or 120 years from creation if it's not immediately published. That means that this PowerPoint is protected by law until, I guess, 2112. So don't think that you can copy it and use it for your own purposes. This last bullet item is important. We can use the example of a book. I think we use that in the copyright law paper. But you can think of it as a set of documents that you provide a project owner. If you have a book, you have certain rights. You can burn the book, you can read the book, you can lend the book to someone, you might be able to resell the book, but you can't copy the book, you can't resell mass editions of the book by copying what you have. You don't have those rights because when you buy something, you don't also get the copyright to it. Now, this is a huge area of the law right now because of licensing and music and online publications and books that you can purchase now in electronic form. Remember that in the old days, when you bought your set of Beatles recordings on CDs or movies on DVDs, you owned that copy. You could not, duplicate it. You could not show it for profit. You could not do a number of things with it, but you own that copy. Now, if you're downloading music from iTunes or from a streaming site, and you're playing that same Beatles music, you don't own anything. All you have is a license to listen to it. So that license disappears. It disappears with your death. In the past, you could give your Beatles collection to some relative who might share your tastes. Now, when you have nothing but a license for it, you can't do anything with it. And statutory copyright, this is how rights are lost or transferred. You can transfer your exclusive rights or any part of those rights in a writing signed by the owner of the copyright. So if you can sign away the rights you have. The licensing language in the standard contract transfers on a non-exclusive basis the right to use the documents, the deliverables that express your design. And you don't really need to put that in writing. You can transfer rights on a non-exclusive exclusive basis without something in writing, but it certainly makes sense to spell out what rights are established in that license and the limitations of those rights. Copyright is a personal property right. It's subject to various state laws and regulations, but you can transfer personal property. Often, for instance, if your firm merged with another firm or actually was bought out by another firm, that other firm is buying the assets but not the liabilities of your firm. And in doing that, it's also buying whatever copyrights you have because they are an asset of your firm. And just note, there is no such thing as an international copyright. Some firms have seen a problem here where documents, or at least the architectural design of a project, is duplicated abroad, unless there also is a copyright law in that country that can protect your design and your documents, and unless you go through whatever process it is in that country to do so, your designs can easily be easily copied internationally. And many large firms have a problem with this because they will come up with a preliminary design. Someone else is going to be doing the construction documents, and before that is finished, somebody else has copied the design because they're not protected internationally. Let's talk about when protection occurs. There's always questions about the formalities of establishing copyright, but really there are no formalities. If it's a creative effort, it's something new, original, novel, as soon as it is put into a tangible medium, it is protected. An idea is not protected. The expression of that idea generates the protection. Right? So if it's original, created by your independent labor, not derivative of somebody else's, the protection applies immediately. You can always add a copyright date and ownership information. There's various forms of indicating that protection. None of them are necessary. But the statement that someone has a copyright with a date and the name of the owner of the copyright gives everyone a warning that the instruments of professional service, in the case of design professionals, that instrument is a protected document. Without that, there's still protection, but establishing the creation or publication date is more difficult. So putting a copyright notice on something, if nothing else, provides some kind of a chilling effect to tell infringers, wait a minute, don't touch it. Now, you can register a copyright, and the more complete status is to actually register the copyrighted material. That involves some difficulty, some cost. It's rarely carried out by design firms, but it does provide some benefits. Injunctive relief, so you can prevent people from going ahead with something that infringes on your copyright. You can recover actual damage and profits made by the infringer, and if it's properly filed, you can recover statutory damages and legal fees. Now, you don't have to, immediately file. If you do it within 3 months, you have some protection. If you do it before you bring a claim against the other person for copyright infringement, you still have some protections, although not as great. If you look at the specifics of copyright law, there's basically 3 categories through which the design produced by an architect or an engineer, actually by an architect, can be protected. For an engineer or other design professionals, only these first 2 probably apply. For architects, your specifications are literary works and are protected as literary works. When you do drawings and models, those are pictorial, graphic, or sculptural works. They fall into that category and they have the protection. If you're an engineer, again, same is true. Specifications and drawings are protected. If you're an architect, you also have that architectural works copyright law protecting you, and that's the creation and publication of an original design, the actual design of something. And if you're the copyright holder, then you have the exclusive right to reproduce the work, including the instruments of service, right? You can prepare derivative works based on that work. You can distribute copies of the work, and you can display the work publicly. So there's a lot of rights that a copyright holder has. In many cases, there are other protections that an owner can have to keep you from, for instance, selling the same design over and over. But that depends on how much of it is actually being sold. Now, this, I mentioned the architecture works copyright law. This is actually what it says. This came out of Circular 41 of the Copyright Office. And this is a part that was added to the copyright law in 1990. Note that the protection is only afforded to structures designed for human occupancy. That center provision basically says it covers the design but not standard elements of the design or parts of the design that are functionally required. So it's really the overall look. This is, there's not really significant case law construing this language, and that's what lawyers try to do when they look at things like protection. What does the case law say? There is the Paycock-Freed idea that protecting the overall look of the Rock and Roll Hall of Fame was able to be enforced. Here are the publications that, if you want more information on the copyright law and how it affects design professionals, just download these from the copyright.gov website. There's one that's Copyright Basics, and talks about what copyright means, how it's obtained, what it costs, what needed to be sent in the register of the copyright. The Works Made for Hire has a different circular. Copyright registration for works of visual arts talks about what has to be required, as does deposit requirements. That part, as you see, it's 40A. That part changes as more things are done digitally. Many things can be filed in digital form rather than in samples. Remember that with publications, with most books, for instance, they actually have to have copies of the books, and those copies of the books are added to the Library of Congress. So it's a way, the idea of copyright also was a way to build the Library of Congress holdings over the years. And the copyright claims in architectural works, again, talks mostly about the design aspects of what you do. Okay, let's address what happens when you license the use of deliverables or transfer your intellectual property to others. Okay, licensing really can provide the parties in the design and construction process with what they really need, whether they are the project client, a contractor, an independent party who has to input information into the design, or the eventual users of the facility. So you have to look at what happens when you license to a client use for a client, and what happens when you can license a use by others who are not part of that chain of contracts that the client is. Transferring the actual ownership of the deliverables is different from transferring ownership of the copyright to the deliverables. In fact, many lawyers who work with project clients do not understand this. We look at a lot of contracts and we see a lot of situations where lawyers will ask that the deliverables, the ownership of deliverables, be placed in the project client. That's fine, but they can't do anything with them because they don't have the copyright to them. So they can't duplicate them, they can't use them for other things. That copyright remains with the original creator. So sometimes transfer agreements are more specific. Sometimes they'll talk about works made for hire and whether or not your design, your plans and your specification are work made for hire. That's questionable. And the other part of it is that there is this special architectural work copyright, and many owners don't understand that, as in the case of the Rock and Roll Hall of Fame. So you could transfer the ownership of documents, you can transfer the ownership and copyright to those documents, you could transfer the ownership of the documents, the copyright to the documents, and a copyright to the design. And those are all three different rights that you have. Now, usually you don't want to transfer, you want to license. And this is what the AIA and EJCDC documents say about licensing, right? The AIA grants a non-exclusive license to use the instruments of service. Why? Well, exclusively for that one project. And again, this has been broadened over the years, so owners can have it to use for additions and modifications, but it is still a limited license, right? The engineer license is much the same. It's the use for extensions and other related uses. Now, the part that I mentioned, the Article 9 language in the new AIA 2007 Owner-Architect Agreement changes how what happens in the case of a termination. And what it really tries to do is to get owners and architects up front to set a termination fee and a licensing fee. The idea is that in the past, there used to be termination costs that the owner was supposed to pay. Owners usually scratch that out of the contract right away. The most they would pay you is for the reimbursables you paid for and the services you provided up to the time of termination, not paying your lost profits, not paying those other commercial losses that you might have. So the AIA changed all that in the 2017 documents, and they said, okay, right up front, when you're talking with an owner, before the owner even thinks that they might terminate the project for any reason. Talk about what a termination fee would be. And as part of that, talk about what the licensing fee will be. So if the owner intends to continue to use the architect's instruments of service, if the contract is terminated for the owner's convenience, what does the architect get out of it? So you set that up front. Now, you could always negotiate that in the past, and in fact, a lot of architecture firms did. Many firms would look at licensing fees and say, okay, owner, you have the right to use whatever documents have been created so far. I will remove our firm's information from them, and you will pay us for instance, half of whatever our remaining fee would be. Figuring that that was a justifiable amount of money for the owner to acquire the rights to the documents and to the copyright, the rights to the copyright to those documents. That, of course, sometimes benefited architecture firms in a great way because often they lose money during the construction phase, and if they got paid at least half of the remaining part of the contract, that was more money than they might, more profit than they might expect. But now you have this licensing fee negotiated up front, and remember the license is only for some specific uses of the document. When you transfer rights to use documents to other parties, you have to be very careful. And the AIA in the C-106, which is the digital data licensing agreement, because most of the information is being transferred digitally, came up with this. At times, other parties have to have access to the instruments of service to use them in designing other components of a project or even an actual construction. And if the party wanting to use the documents is not in the chain of agreement, is not the owner or someone subcontracted to the design professional or the contractor, or in the chain going down from the A201 through the contractor, you have to come up with a way to license it. And this is what the AIA came up with in 2013 and in the C-106. Note that you can only license the use of the documents if the project owner does not have an exclusive license to use the documents. And of course, if for some reason you signed a contract because the owner convinced you or coerced you to accept a transfer of rights to the owner in the documents upon their creation, you can't even do this. You no longer have control, and you cannot share the documents with anyone. The project client, in that case, would have to be the one who shared the transferred documents. So if you're transferring ownership to of the documents, ownership of the copyright, ownership of the design to the client, you don't have any rights in them. So you can't reuse them, nor can you license them to others. Now, let's talk a little bit about the issues in transferring ownership of the documents, or ownership in the copyright of the documents, or even ownership in the design of the architecture or work. There's issues you have to address. We'll reinforce these by just reading what's on the slide. You have to decide what rights are actually being transferred. Okay. You should base that on a full payment of all the sums due or anticipated to be due, so that you're not giving away stuff before you can collect your fee. You probably should retain the rights to your electronic data and even reproducible documents of the drawings and specifications, and the right to reuse information contained in them in the normal course of your professional activities. Many times you'll see developers who understand this. They know that they want to preserve the look of the project. They know they want to be able to use the documents in the future, and they want control of that. But they're not taking away from you the right to use design details on other projects. But you should be aware that that could happen, and that's something you don't want to happen. Retain all rights specifically, not specifically conveyed. Again, you may have the right to the architectural work, the overall design, because the owner did not request that. And one thing you do is you establish the sole risk of the person you're transferring the information to. That doesn't always protect you, but if the documents are used without your professional involvement, you have the ability to say, look, they waived any rights against me. They took the risk on themselves. Any third-party risk should be against them, not against me as the original designer. And some other issue, the one that of course often holds up in negotiation, is the right of the requiring the transferee to indemnify and hold harmless the design firm from anything that might happen from reuse of the instruments of service. That makes sense. Why would you be, if you're sued, if it's a meritless claim because someone down the line realized that you probably designed them, or for some reason you left some identifying information on the documents, you don't want to be held responsible for how others changed the documents, what the owner did with the documents. That may not come up. That's often easily defensible, but having the indemnity in place can really help. And again, saying that you're not selling documents, right? You're selling the rights to the design, the instruments of service for that design. So you avoid those product liability warranties that aren't covered by professional liability, the warranties, the merchantability, fitness for a particular purpose, those provisions. And again, this information is in all our standard stuff on our Schneider.com AE risk management website, and even in things like the AIA B503, which is a document that is updated every so often, that comes up with alternative language to the standard AIA owner-architect agreements. This is the kind of thing that you see when an owner's attorney gets involved and wants the owner to have the rights to it. They may come up with this kind of a provision. They really attempt to effectuate the transfer of the ownership of the documents and the copyright to those documents. Often transactional attorneys do not understand the copyright law, so they try to cover all their bases by stating that the documents are work made for hire, but because they're not sure and the law is not clear that the documents could qualify as a works made for hire, they tried to cover it by saying, okay, and if they are not, we still want the exclusive right to those documents. This language, of course, does not make it clear when the transfer takes place. Most attorneys in this situation would say, well, you know what? They take place as soon as you create the document. So because you're transferring all your rights to us, as soon as you do something creative, as soon as that reaches a tangible medium, whether it's notes, whether it's sketches, whether it's design development drawings, or whether it's construction documents, they are ours. And that's where you lose all the leverage you have. Because if that's the case, if that's the argument that they can sustain, they are basically saying, we don't need to pay you. You know, you already have given us all of the intellectual property. Now, again, you know, what are some of the concerns? You know, that owner's language does not tie the owner into paying for the services, right? If you don't have that link, and this happens a lot with standard documents like the AIA documents, part of it will be changed. The ownership of documents, the ownership of the instruments of service will be changed, but the compensation part will leave it open. And you may be providing the owner with information the owner never has to pay for. So you want that link between the transfer of information between the termination and the control of documents. You need that link. That language also had no recognition of the reuse of design details, no protection for meritless claims against design firms who create the stuff because of the reuse of intellectual property, and no clear statement of the ownership of the design under the Architectural Works Copyright Act. So, you need to address some of those issues. Now, we're going to briefly go over a kind of a case study. I know that it is rare that when an architect or an engineer or other design professional tries to enforce copyrights, tries to enforce what the law provides the creative design professional, rarely does it really benefit the architect or the engineer or the other design professional. And an example of that is the infringement of architectural drawings by a developer. It's a situation where an architect prepared the drawings and specifications for an apartment building without the permission of the architect. The developer copied, slightly revised the plans to produce another set of plans from which the developer built a similar apartment adjacent to the first. The architect discovered that the plans were copied. So the architect first billed the client for what the architect would have charged for designing the additional building, and then commenced an action for copyright infringement and sought actual damages and profits made by the developer, which, as you know, the law will allow if you register your plans. As to actual damages, the architect should have been entitled to the fair market value of the plans. The judge looked at what the developer would have paid the architect and what the architect would have expected to receive for those plans. The architect's bill to the client, however, was based on the estimated construction costs and a percentage fee. The judge saw through that and said, look, you were not providing any construction phase services, so that fee doesn't make sense, and cut down the fee significantly. The judge really found that it would be inconceivable for the developer to expect to pay more for the second set of plans than they did for the first. So the judge looked at the first fee for the design until the construction documents and subtracted from that what the developer paid to make changes to the design documents. And, we mentioned that federal copyright law gives the claimant any profits of the infringer if you're properly filing the documents. You can file for those profits. The infringer actually has to present proof to subtract from kind of the gross revenue that they would have received. It has to prove that the expenses and the other elements of profit that would be attributed to facts other than violating the copyrighted work. In this case, the judge refused to award attorney's fees to the plaintiffs because the infringement actually occurred before they registered the copyright, so that part was out. The judge did award the damages, the profits that the architect would have made on the original, preparing the original documents without the extra construction phase services, and the profits earned by the developer. So it went from a claim that was significantly high to a claim that amounted to about $25,000. And I'm sure in this case, the attorney paid far more than that in legal fees. So these issues of copyright infringement are never easily solved unless you can coerce a payment in the settlement. But if you take them to court, you're not going to get very much money. It's going to take a long time. And rarely have I seen a situation where the architect ever gets more than legal fees. Now, you may want to do that simply to punish a developer, to simply try to protect your rights. But it's far better to try to license the information up front, get paid for that license, than it is to try to file a copyright action against someone. I think we're going to be seeing this happen more and more because as things are easily transferred digitally, we're going to be seeing more and more details and plans and specifications copied. I think there's going to be more violations of the copyright law in everything we do in society, especially in design. And I'm not sure it's going to be worth your while to try to pursue that. Now, in summary, let's leave you these 3 points. One, yes, they can assist you in collecting a fee. That's the part that you want. You want to make sure you get paid for your project. You can license the use of the plans and specifications. That almost always meets the needs of the client rather than transferring information to the client, transferring ownership of the documents and the copyright and the design. You can license the use of your instruments of service to non-contractual parties through a separate licensing agreement. You can transfer the ownership of the plans and specifications and the ownership of the copyright and to the design, but you have to carefully negotiate that to obtain full payment, right? You don't want that transfer to take place until you're made whole. You can reserve the right to reuse details from the project, and you want to obtain protection from third-party claims from the future use or misuse of your intellectual property. So keep that in mind. Again, that's in all the information we publish on our website. And the recommendations, I want to make sure you know that intellectual property is more than just what you create. Owners are very concerned about keeping their information confidential. That's why they have you sign those non-disclosure agreements. So treat all information as if it were protected intellectual property. Just as you want to protect your information, they want to protect theirs. And we have information on our website about non-disclosure agreements and other concerns that owners might have when they give you information. Do not share information on one project with a client on another project. Do not publish information on a project without the owner's consent. That's all protected information. And for protecting your deliverables and your design, it's easy to add copyright notice to what you do. Right? It might help to prevent someone from thinking that all information is free. Right? We're into this age where all information is on the internet. It's all free. So if you put that copyright, the date, and the firm on what you produce, at least you're giving someone warning. Since we've been talking about using the law as leverage, do not sign contracts to give away what you develop as soon as you develop it. Use any licensing or any transfer of rights as leverage for your payment. If you do license on a non-exclusive basis or transfer the ownership and copyright to deliverables, be aware that you cannot then allow others to use them, nor, depending on what you transfer, can you develop derivative works based on the intellectual property you no longer own. So if you're transferring all the rights, make sure you know what rights you might be able to retain. At times, a client will give you a set of incomplete documents to finalize, or maybe a complete set of documents because they want an addition or a modification to what they're in now. Be very careful about that. Do not blindly accept them, since you might actually be sued by the actual copyright holder. Again, because the client owns a set of documents doesn't mean the client owns the copyright to those documents, the copyright to the design. So if the owner is asking you to use what somebody else has generated, be very careful about that. You want proof that they have the right for you to use it. You might try to add to that an indemnification so that if you get sued, the client will defend you against the suit from the original design firm. You might also find that if you do this, you will violate state registration laws. So be very careful when the client asks you to use something that the client already has. And as a reminder, here's the URL for our risk management website. If you have not already registered to use it, you should. And again, it has information on how you can protect your documents, how you can license the documents, what the standard contracts say, and it has the other information on copyrights that we're providing you.